Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice. Thank you. Please be seated. Good morning, everyone. I want to welcome you to the September 28th, 2020 land use hearing. My name is Susan Finch, and I'll be presiding as the hearing officer over today's cases. Let me start by introducing Mr. Tom Hisney to my left, who will go over any changes we have to today's agenda. Mr. Hisney.
Good morning, Madam Hearing Officer. To my left is Carmen Mason. She's on Development Services Operations Support Staff. In our meeting today, we'll also be joined virtually by Cameron Clark of the County Attorney's Office. We have no changes to the agenda. We do have the following published withdrawals and continuances. Item A1, variance application 20-0324. The applicant is Raul German Rodriguez. This application is out of order to be heard and is being continued to the October 19th, 2020 Land Use Hearing Officer meeting. Item A2, variance application 20-0352. The applicants are Michael Simaluka and Cynthia Fernandez. This application is out of order to be heard and is being continued to the October 19th, 2020 Land Use Hearing Officer meeting. And finally, item A3, variance application 20-0400. The applicant is Jamel Ruiz Bielsa. This application is out of order to be heard and is being continued to the October 19th, 2020 Land Use Hearing Officer meeting.
All right, thank you so much, Mr. Hisney. Let me start by going over our procedures and hearing process for today's hearing. I'll conduct the variance and one special use hearing today and render a decision within 15 business days following today's hearing. Our hearing today is informal. I'll ask questions related to the direct testimony presented today. I'll call and question witnesses as I deem appropriate, and will decide all questions on procedure. Irrelevant, immaterial, or unduly repetitious evidence will be excluded. Any part of the evidence may be received in written form, and all testimony must be under oath. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but shall not be sufficient in and of itself to support a finding by me unless it would be admissible over objections in a civil action. Our order for presentations is as follows. We have most of the agenda items today are variances. And so with variances, the Development Services Department person assigned to the case, the planner assigned to the case, goes first. They will present their findings and staff report information. Then second, we will go to the applicant. The applicant has 15 minutes to make their presentation. Next, we turn to proponents. Anyone who would like to speak in support of an application. Total proponent presentation time is 15 minutes. The same is true next when we go to opponents. Anyone who would like to speak against an application. All told, 15 minutes for that period. Then next, county staff, 5 minutes to address any issues that might have come up during today's hearing. And then finally, we'll go back to the applicant, who has 5 minutes for rebuttal to address any issues or items. The only difference with the special use, that is the last item on today's agenda, is that the applicant, the Development Services will just provide a brief introduction, and then the applicant will go first on that with 15 minutes of presentation time. When you come up to the microphone, if you are going to speak or if you are speaking virtually, if you could please always start by giving us your name and address for the record. We are recording this hearing, and we want to make sure through both visually and through the transcript that we can identify who is speaking. And then when you're finished, if you could see Allison on my right, she's with the clerk's office. She has a sign-in sheet. And so when you're done speaking, if you could go see her and sign in with your name and address and also the case number that you're speaking to. Let me now turn to Mr. Clark of the County Attorney's Office to explain your right to appeal decisions made by a land use hearing officer. Mr. Clark.
Thank you, Madam Hearing Officer. My name is Cameron Clark. I'm an Assistant County Attorney. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the appeals board. In reaching a final decision on petitions, the appeals board will only consider the decision of the hearing officer and the record that is made at this public hearing. If an appeal is filed, the appeals board hearing shall consist of oral argument by the party appealing the decision, by county staff, and by any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. First is the applicant. Second is anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the appeals board that is outside the record created at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action then is for you to write down any comments that you make today and to repeat those comments to the appeals board. Thank you.
Thank you, Mr. Clark. I appreciate it. All right, as I mentioned, all testimony must be under oath. So if you do plan to speak on any case today, if you could please stand and raise your right hand, and do the same if you are addressing us virtually. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please be seated. All right, Mr. Hisney, if you could call the first case, please.
All right, on today's agenda, we have no vested rights cases, no fee waivers, no reconsideration requests, no site development variances, and no sign variances, which takes us then to section G of the agenda, which are general variance requests. First case is item G1, variance application 20-0137. The applicant is Francisco Otero Casio. The request is a variance to accessory dwelling requirements, and I will present staff findings in the case. The applicant is requesting a variance to accommodate a proposed accessory dwelling on property located on a corner lot within the RSC3 zoning district. Land Development Code states that accessory dwellings shall meet principal building setbacks. In the RSC3 zoning district, a minimum side yard setback of 7.5 feet is required. So the subject property is a corner lot with required front yards on the north and west sides and required side yards on the east and south side. The applicant requests a 0.7 foot reduction to the required east side yard setback to allow a 6.8 foot setback. Allow me to point out that the Land Development Code limits accessory dwellings to a maximum of 900 square feet of living space as described in the code. It appears from the submitted floor plan and site plan that the living space in the proposed accessory dwelling will exceed 900 square feet, notwithstanding site plan notes to the contrary. A variance cannot be requested to increase the amount of living space for the subject accessory dwelling because the principal dwelling in a lot does not have more than 3,600 square feet of living space. Staff has advised the applicant that the design of the accessory dwelling must be revised if it's determined at the time of building permit review that it indeed exceeds 900 square foot of living space. And I would ask the applicant in their presentation to confirm their understanding of this requirement.
All right, thank you so much. Is the applicant here?
I believe he's virtual. Are you there?
Yes, I'm sorry. Good morning. I'm here. Can you hear me?
Yes, we can. Go ahead.
Okay. Good morning. My name is Francisco Otero Casio. I'm the applicant. My address is 4521 West Ottawa Avenue, Tampa, Florida, 33614. And yeah, this one's a pretty straight up variance, like Tom said, where we're requesting a 0.7 foot reduction on the required side yard setback. And then the other issue is that the accessory dwelling cannot exceed 900 square feet. We originally submitted building plans that were over 900 square feet, but to confirm, we will adjust our plans to limit the size 900 or less square feet. And there was also another issue where there was an adjacent storage facility. Well, that will remain shed and not living. But to clarify again what Tom has said, we do confirm that the accessory dwelling will be less than 9. So if the variance is approved, we will adjust our building plans for the permit. And that concludes my presentation.
I have one question, and that
Yes.
is, it looks from the site plan that the proposed accessory dwelling unit, is it attached to the existing shed?
Yeah, it is attached, but there will be no door going into the shed. So the only access will be to the outside of it. And that was another comment from the plan reviewer that there definitely cannot be no access to that from the accessory dwelling.
That is the setback issue because you attach it to the shed, correct?
If Tom, can you clarify that? I'm not sure.
The site, I'll clarify it for you. The site plan I'm looking at shows 6.8 feet to the shed. And so I just wanted to clarify for the record that.
Oh, yes, 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 you're correct. Yes, you're correct.
The
Yes.
accessory dwelling unit to the shed, then all of a sudden that becomes subject to those primary setbacks.
Yes, ma'am. Yes, ma'am. You're correct. I'm sorry.
That's my only question. Thank you.
Okay.
Here that would like to speak in support of this application. Anyone in support? All right, seeing no one, anyone in opposition to this application? All right, no one? Mr. Hisney, anything else?
No, ma'am.
All right, then with that, we'll close variance 20-0147 and then the next case.
All right, our next case is item G2, variance application 20-0257. The applicant is Mobley Homes Tampa LLC. The request is a variance to lot development standards. Staff findings will be presented by Steve Beachy.
All right, Mr. Beachy.
Good morning, Steve Beachy, Development Services. The applicant is requesting 2 setback variances for an existing single-family home on a lot zoned RSC4. Per Land Development Code 60101, the required minimum side yard setback in the RSC4 district is 7.5 feet. The applicant requests a 1.2-foot reduction to the required side yard setback to allow a setback of 6.3 feet from the south lot line. The second variance is for a special yard setback per Land Development Code 60103G. The yard on the east side of the subject lot constitutes a special yard, which is subject to the rear setback requirements of the property's zoning unless the administrator determines that a side yard requirement of the districts are applicable. In the subject case, there's no record of an administrator rendering such a determination. Per Land Development Code 60101, the required minimum rear yard setback in the RSC4 district is 25 feet. The applicant requests a 9-foot reduction to the required special yard setback to allow a setback of 16 feet from the east lot line. According, as far as the findings, according to the applicant, the encroachment of the home into the required side yard on the south side of the lot is a result of a builder modification at the time of construction. Also, the setback from the east property line is consistent with the setback shown on the approved building plans for the home. However, again, there's no record of the administrator rendering a determination that the special yard on the east property line was subject to the side yard setback requirements rather than the rear yard setback requirements. That concludes my testimony.
Thank you so much. Mr. Malloy.
Good morning. William Malloy, 325 South Boulevard, Tampa, Florida. As Mr. Beachy said, we've got 2 requests this morning. One is for the southern side yard, which was drawn at the requisite 7.5-foot setback and ended up at 6.3 feet. I'm told that was a result of settling during site development. And I'd like to point out that no attempt was made to hide that error on the as-built, and it was not an issue until more recent events brought that to light. Second is the rear yard setback. As you can see, this is not your typical rectangular lot that falls in with the other ones in the neighborhood. In this case, the structure was constructed and designed and approved, but a subsequent closer look again required what constitutes, I guess, a second look as to what's the side yard and what's the rear. As I said, the last time I was here when we had continued this one, we were subject to an ongoing Swift Mud review for the overall operating permit and drainage system in the neighborhood. Swift Mud has come to a final conclusion on that, which I did not see in optics this morning, so I brought a few copies of.
Just give one to them.
In that report, you'll see that we do have a bit of work to do in potentially raising the fence line on this lot, among others, and taking a look at the grading of what is supposed to be a rear swale on this lot, among others. That being said, I don't believe either of those considerations really weighs on the placement of the structure as it relates to drainage. So with that, I'm happy to answer any questions you have.
Just a couple quick questions. When was the house built, or what stage of construction is it at?
I believe it was built more than 2 years ago, so it is fully constructed and
finished.
occupied.
Okay. All right. And the builder error is, that applies to the side yard. I understand. Okay. All right. Thank you so much. I appreciate it. All right. Is there if you could sign in, please. Is there anyone that would like to speak in support of this application? Anyone in favor? Seeing no one, anyone in opposition to this application? No one? Okay. Mr. Hisney, anything else?
No, ma'am.
All right. Then with that, we'll close variance 200257 and go to the next case.
Susan? Could I?
Excuse me?
Yeah, this is Steve Beachy. I'd like to say something.
Oh, all right. Mr.
Can you still hear me? Yeah, I was not aware that the determination had been made by Swift Mud. And Mr. Malloy raised an issue about the raising of the fence height. I'm wondering if he could speak to that, because if it's going to go over 6 feet, there may be an issue with, they may need another variance.
Mr. Malloy, if you could address that, the fence height that you mentioned.
I believe raising the fence height as it pertains to this particular situation, and we had to do it once at the beginning of this year to satisfy development services, is maybe not so much physically lifting the fence, it is making sure there's clearance between what is the bottom of the fence and the ground underneath, because the way the drainage system works, the water from the neighborhood adjacent is supposed to flow this way. So I'm not going to stipulate that raising the fence is going to take it over 6 feet. In fact, I can see that we can make sure it won't. We just need to make sure there's clearance under the fence for water to flow.
So just for the record, you're not asking for a fence height variance in any way?
No,
you'll adhere to the regulations?
I have not contemplated that. No.
Thank you so much. All right, then with that clarification, we'll close variance 20-0257. Go to the next case.
All right, the next case is item G3, variance application 20-0351. The applicant is Joshua and Caitlin Lovely. They're requesting a variance to minimum lot size by available utility to allow a third lot on septic tank in the urban service area. Staff findings will be presented by Colleen Marshall.
Good morning, Colleen Marshall, Development Services. The applicant's requesting variances to the minimum lot size required for septic tank and to allow a third lot on a septic tank in the urban service area to accommodate a proposed subdivision on property zoned RDC 6. Per LDC section 60106, a minimum lot size of 1/2 acre upland is required for use of septic. The applicant's requesting a 7,056 square foot reduction to the required lot size for the southernmost lot to allow a lot size of 14,724 square feet. A 6,486 square foot reduction to the required lot size for the centrally located lot is requested to allow a lot size of 15,295 square feet. All the proposed lots will meet the minimum lot size required by the RDC 6 zoning district for one duplex on one lot. Additionally, the applicant requests a variance to allow the creation of 3 lots to be served by septic tank in the urban service area. Public Utilities staff has confirmed that connection to public wastewater service is not cost feasible for the proposed 3-lot subdivision. Background information is provided in the staff report regarding the property history for your information. I'd be happy to answer any questions.
I have just a couple of questions for you.
Sure.
First, in reading the backup in the staff report, it looks like that the applicant applied for a duplex on that vacant lot. And then that's how, it appears that's how this all got started. So is it really a review for 4 lots at the end of the day? Because they're looking to subdivide the existing lot that has a duplex unit on it, on one lot, and then put another duplex on the second lot. So would it be a total of 4 lots? Is that correct?
No, it'll be a total of 3 lots. So the owner of the vacant lot recognizes that they can just put 1 duplex on 1 lot. They'll be, and the applicant will be able to speak to it a little bit further, but they have worked with the owner of the other half of the parent parcel to create 3 lots that would meet the RDC zoning district. So I believe they'll be selling or giving some of their land to the other property owner to be able to accommodate the 2 existing duplexes, each on their own lot, to meet the RDC 6 zoning district. And then they will have the 3rd lot and be putting 1 duplex on the 3rd lot.
So would the 1 duplex on the 3rd lot be required to be subdivided?
No. You can have 1 duplex per lot. Well, so it'll be subdivided as part of taking this parent parcel into 3 if they get the variances approved. But for the purpose of a duplex, the duplex would be on 1 lot and that would be permitted.
I see. So there's 2. All right, I understand now. So there's 2 duplexes on the southern lot, correct?
Currently, yes.
The reason for the requirement to subdivide that lot.
Correct.
Understand. Okay. And then secondly, could they come in, could the property owner to the south that has the 2 duplexes, could they come in with that single lot and request the variance to subdivide that lot with the 2 duplexes, and if it were approved, then be a conforming lot, excluding the 3rd lot, the vacant lot to the north?
No. So when we look at the parent parcel, this split where we have 2 properties right now was done by deed only. It wasn't done through development services. And the other problem with the split is that it creates what was already a non-conforming lot as a parent tract with 2 duplexes on a single lot. Now having 2 duplexes on a single lot that's smaller, it increased the nonconformity. And so they have to remedy that situation, but they wouldn't be able to do that without working with the property owner to the north because it's all part of what was 1 parent parcel.
Parent parcel was subdivided. Let's see, you said July 15th, 2005 is what it says in the report. And that created the 2 lots, a vacant lot and then the lot to the south that has 2 duplexes, correct?
Correct. But it was.
And so in order for them, the only reason for then this request in your review is that they want to develop the lot to the north, the 3rd lot.
Correct. And so to be able to do that, they need to remedy this situation where they've been split by deed and not through development services. So that's why they're requesting the variances so that they can bring all of the parent parcel into compliance when they subdivide.
Would the southern lot with the 2 duplexes be required to subdivide had it not been for this request for the 3rd lot? Like if they went to pull a permit for anything on those 2 duplexes, would they be required to subdivide?
Yes, they would have been required to remedy the situation similar to how the applicant is doing in this case. Because it wasn't properly subdivided. Had they left it the parent parcel with the property to the north as one large parcel, they could have sought a non-conforming determination of nonconformity for the two lots on one, or two duplexes on one lot. However, because of making that property smaller, they increased the degree of nonconformity more than 50%, so they couldn't, they wouldn't be able to request a special use for an expansion of a nonconformity at that point.
Variance. The subdivision of that lot. Is that correct?
I'm sorry, I didn't hear the.
They would need a variance to correct it. The two duplexes on the one lot, they would need, because they can't increase that nonconformity, they would need a variance to correct that.
Yes, they would need a variance, and then they needed to have more area. They're over density based on the lot, the way that the current split is, their lot size is over the density for the zoning district. So they needed to gain more land essentially to have the 4 units total based on the acreage.
Thank you so much. I appreciate it. Is the applicant here? Good morning.
Good morning, Ms. Finch. Michael Horner, 14502 North Dale Mabry Highway, Tampa, representing Mr. and Mrs. Joshua Lovely, who have been caught up in this most unfortunate set of circumstances for years. So thank you for your questioning. Now I think that lays a good predicate and foundation for what we're up against. Through no fault of my clients, they find themselves in this situation where we have to go back and erase time, essentially, and go back to where this lot should not have been created. It should not have been sold, and my client, if he could go back in a time machine, would not purchase it. But he didn't know. He was represented as a deed, arm's length sale, all good. He spent a lot of money on this duplex lot. We'll call it the north lot. My client also has a construction loan. So he has both the mortgage he's been paying off. He also has a construction loan to build. Well, he was hoping, Ms. Finch, was 2 duplexes, similar to the south lot. Unfortunately, he is now precluded under the current LDC requirements and density requirements. You can only have 1 duplex on that entire north lot, which is 0.69 acres. All right, so you can see the addresses, Ms. Finch. This is Alfred. This is the south duplex lot. This is what my clients have purchased. You can see the addresses for each of the proposed duplex tax record. That was always anticipated to have 4 duplexes. I might also say with me is Mr. Joshua Lovely, who will just make a brief comment on his frustrations after I complete my testimony. Also, we have Mr. Bill Fenzow, who's the contractor, who's been working with my client for years in getting septic tank permits, trying to file platted subdivision without improvements, trying to do certified parcel. All of those efforts, design drawings, all of those efforts are for naught until we get through this process. So we also have Ms. Karen Rodriguez, who is a relative of the conveying party, who is not the applicant, but is here to speak on, they were part of that conveying party. She did not personally convey it, but she is here to lend her support because she knows what her family did has put my client in a very difficult position. So here we are. This started, as I said, several years ago. We are RDC 6 zoning. We are Res 6 in the comp plan, so we do have a density issue in the comp plan. We're urban service area, typically public water and public sewer required. You heard Ms. Marshall indicate that we are essentially permitted not to extend public sewer because it's too far away and it's only for one structure. I would note for the record that all of these lots are all on septic tank, including the large church to our immediate north. So the two duplexes, Ms. Finch, are on the south tract, and that lot was created, let's just say non-conforming. I don't want to use the word illegal, but it did not follow the county regs. That set the wheels in motion for a number of things. They had two structures on one lot, as Ms. Marshall indicated. They also had 4 units on 0.63 acres, which is in violation of the comp plan density of Res 6, which is 6.3 units per acre. So we had a number of issues to work through on this going forward. I want to commend Mr. Hisney and Ms. Marshall, so kind and so professional, worked us through all the way through January, February, March, continuations on COVID, but now we're here and we're thankful for their assistance. My clients need to get this resolved today, hopefully in 3 weeks. So those two duplexes should not have been cut out. That parcel in the north, 0.69 acre tract that my client purchased for 2 duplexes is what he was pursuing it. A lot construction loan, paid for the actual loan on the purchase agreement. We tried a certified parcel. Mr. Fenzow has a file about 6 inches thick on all of those efforts to try to legally conform. They were stopped at every step of the way, saying we can't accept a certified parcel that memorializes an illegal lot split. So you can't go any further. I'm sorry for all the money you spent, all the misrepresentations, and yes, you have a deed. The deed was not properly recorded, and the deed was not properly submitted to development services to meet minimum lot size LDC requirements. Ultimately, the only solution, Ms. Finch, was to go back I want to reduce this. I want to make it smaller. We have more. There we go. Great, thank you. So the only way, Ms. Finch, for us to proceed, for my clients to ultimately get a permit, and that's all I've been asking for 7 years, is to create the south lots, borrow from the property that he purchased. How's that for the irony? He purchases the biggest lots, and now they are forced to actually give some of that lot back to this lot because they have a density issue for the 4 units. So my client conveyed at no charge to this property, and we created 2 lots. You can see this gerrymandered line to meet the minimum 3rd acre requirement, which is necessary for well and septic tank. And then we are seeking waivers for those 2 lots because they are not obviously 21,780, half acre. So the variance is for the north lot, which is now, you can see it's larger, 15,295. We're asking for a variance of 6,486 square feet. And the smaller lot to the south is 14,724 square feet. We're asking for relief of 7,056. That meets all setback requirements. They have their own well and septic tank on each of these lots. So the good news is we don't have to share drain field and wells. Easy, relatively easy, straightforward cut. And then my client is left with a smaller tract than he purchased, but it's a tract that far exceeds minimum lot size requirements. His lot, as you can see, is well over a half an acre. Again, it's only for 1 duplex. His dream of having 2 duplexes is just not going to happen. My client will meet all the setback requirements. He also has to have, the density on this, I might add, Ms. Finch, is 2.9 9 units per acre. So this drops from 6.3 to lower, under 6. Overall, this density drops to just below 6 units per acre. So we married these folio numbers together, re-described the lots. We have not filed these deeds until you say yes, and then with your approval, my client will record those new deeds with these 3 legal descriptions. And then we'll have to go through a parcel certification, subdivision plan, that memorializes these lots, and hopefully they can now pull a permit for 1 duplex. These duplexes are not big, 1,500 to 1,600 square feet, 750 to 800 square feet per unit. The client now just wants to have one side of that duplex where he and his wife will now just had their second child. Their hopes and dreams were to start their family in their new house. They're now just having 2 children now that we're hopefully we're going to be raised at this house. The second half of this duplex would be for their mother, a grandma who can be close to the kids. That's the intention. That's the goal. So we have 3 variances, 2 lot size relief requests for these newly created lots, and then simply allowing a 3rd lot on a septic, because we cannot bring in public sewer. We were hoping that this could have been resolved administratively, and I realized very quickly the only way this would work is to put Humpty Dumpty back together again and then recreate and start anew on these lot sizes. The good news is these property owners, this property owner, and you'll hear from Ms. Rodriguez, realize, wow, Mr. Lovely was placed in a very difficult position because of actions of that family. And now we're here to rectify it. I don't think we have any opposition. We're all holding hands together on this, and I would just ask for your approval. Thank you so much.
Thank you. Mr. Horner, were you going to have the property owner speak, or?
I'm going to have Mr. Lovely speak at this time. Thank you. Ms. Finch, also, I didn't mean to negate the criteria. So we filed a pretty detailed 4-page variance response memorandum, also a detailed 3-page history memorandum as well in the record.
Thank you. Good morning.
Good morning. Joshua Lovely, 1312 Alfred Street. He pretty much, obviously gave a good foundation of what was going on. I purchased the property 8 years ago with the obviously hopes of building 2 duplexes. I was kind of cut short on that, saying that, the most you could ever possibly build would be 1 because of the situation that happened in 2005, which obviously I wasn't aware of when I purchased the property. So basically at this point, I've done everything that anybody's asked. They've asked me to get additional surveys and everything that they asked, I've done it. I've pulled out loans to try to obviously, financially to rectify the situation, but I just keep getting stopped at every turn. So just now, basically, this is where we're at this point. So like he said, the property was for me and my wife and my 2 kids, and then my mother to live in the other duplex. My dream was to hopefully, if I was able to build another one for, an investment for my family, but obviously that's, the unfortunate, what happened. So that's basically why I'm here, just to obviously ask for the variance to help me to build.
All right, thank you so much. I appreciate it. If you could please sign in with the clerk's office. Mr. Horner, does that complete your presentation? Yes. All right, thank you so much. We'll go to ask for anyone that would like to speak in support. Anyone in favor of this application would like to speak? Good morning.
Good morning.
If you could just please bring it down to your mouth, yep, and start by giving us your name and address. Thank you.
Good morning. My name is Karen Rodriguez. I reside at 308 West Jersey Avenue, Brandon, Florida. I am in support of Mr. Lovely's project.
All right, thank you very much. If you could please sign in with the clerk's office. Is there anyone else that would like to speak in support? All right, seeing no one, anyone in opposition to this request? No one? Mr. Hisney, anything else?
No, ma'am.
All right, then with that, we'll close. Oh, I'm sorry, Mr. Horner, did you have anything you wanted to say before we close? All right, thank you. We'll close variance 20-0351 and go to the next case.
The next case is item G4, variance application 20-0422. The applicant is Francisco Otero Casio. Request is a variance to accessory structure requirements. Staff findings will be presented by Steve Beachy.
Good morning, Steve Beachy, Development Services. The applicant is requesting 3 variances for an existing accessory structure on a lot zoned RSC 9. The first variance is the rear yard setback. The required setback for an accessory structure is 3 feet. The applicant requests a 1.2 foot reduction to the required setback to allow a setback of 1.8 feet from the south lot line. The second request is the side yard setback. The required side yard setback for an accessory structure is 3 feet. The applicant requests a 0.5 foot reduction to the required setback to allow a setback of 2.5 feet from the east lot line. The third variance is a required rear yard coverage variance per Land Development Code section 61104C3. An accessory structure may occupy required rear yards provided that such structures do not occupy more than 20% of the required rear yard. The applicant requests a 22% increase in the permitted required rear yard coverage to allow a 42% coverage. As far as findings, the homeowner is subject to a code compliance violation, which indicates, among other violations, that the accessory structure was built without permits. Also, the subject structure was previously utilized as an accessory dwelling. However, the applicant has informed staff that it is no longer used for this purpose. This concludes my remarks.
Thank you so much. Is the applicant here?
Yes. Good morning. Francisco Otero Casio, 4521 West Ottawa Avenue, Tampa, Florida, 33614. I know that this
Could
neighborhood
you
pretty
enable
well.
your camera
I
first,
grew
sir?
up in it, and my parents own a house on the same street. And part of the hardship in this neighborhood is that the houses were built, I believe, in the late 50s, early 60s.
Mr. Otero,
Yes,
could you please enable your camera?
I'm sorry.
Good, thank you.
Is that better?
Yes, thank you.
Okay.
Go ahead.
Thank you, sir. Please continue.
Okay. As I was saying, the houses were built in the late 50s, and they were relatively small with no garages, just an open carport. And my client did the addition pretty early on when he bought the house 30 years ago as an accessory structure for storage. He's a retired machinist, and he stores a lot of machinery in there. And then at one time it was rented out, but it came under the conclusion that those apartments are not legal. So he's under the understanding that it will remain a storage only, and without the possibility of being rented out. In retrospect to the lot coverage from 20 to 42%, it is a 20% increase on what the code allows, but there still remains some yards, some green space. And like I said, he maintains his property pretty well. And the accessory was built 30 years ago without permits, and we're under the process now. We also, on this project, we have submitted plans to get it permitted, and it's just on hold pending this variance approval. And once the variance, hopefully, if it is approved, we will proceed to address the final comments to get it permitted. So the house will be, the compliance issues will be complied with once we get the permit issued and the required inspections completed. But we feel the variance is adequate, we respectfully request your approval because it is a pretty big hardship for my client being a certain age and his house being so small that he really does need the storage space to maintain his machinery. Thank you.
I just have a couple of questions.
Okay.
Regarding the timing. You said, you testified that the house was built in the late 1950s, is that correct?
I think. I'm not sure exactly what date it is, but I think it was in either the 60s or it's been over 30 years ago. I'm sorry. I don't know the exact date.
Did I hear you say that your client built the accessory structure 30 years ago?
It's my understanding, yes.
Did.
Yes.
Leads to my question. There's a deed in the backup that says the property was purchased in 2014.
I don't know if that's the one that he refinanced the property, but he's been there from my initial, no, he's been there a lot longer than 2014. So like I said, I grew up in that same street he's on. So he's been there over 25, 30 years.
That might be the case because it looks like the seller and the buyer are the same names. So they're refinancing, but it's your testimony that he's owned the property over 30 years and built that accessory structure back in that time frame?
Yes, I grew up in that neighborhood too, and he's been there probably the same amount of time as I was living there.
Thank you. That was my only question. I appreciate it. Is there anyone that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition to this request? No one. Mr. Hisney, anything else?
Yes, the applicant touched on this, but I'd just like for him to further confirm on the record. So as an accessory structure, this can't be used as living quarters by anyone, not just being rented out. You could not have a family member live there or anything. Additionally, it cannot even be used for sleeping purposes, including guest visits. Additionally, as an accessory structure, if this structure had been equipped with a kitchen and a bathroom, they're going to have to remove the kitchen. It cannot have both a kitchen and a bathroom. So I'd like the applicant to confirm on the record his understanding of that.
Yes, I confirm. And then also too, we would definitely adjust the building plans. If there's no kitchen now, but there is a bathroom. But we confirm that they would never be used for living, and there's no kitchen yet, but the bathroom is allowed. And
the bathroom's allowed, just can't have a bathroom and a kitchen.
Okay, we confirm that.
And again, you can't use it for sleeping purposes or even including guest visits.
Yes, we confirm that too.
Thank you.
All right, thank you. Then with that, we'll close variance 20-0422 and go to the next case.
All right, our next case is item G5, variance application 20-0522. The applicant is Ronnie and Delbra McCullough. They're requesting a variance to lot development standards and to accessory structure requirements. Staff findings will be presented by Tanya Chapella.
Good morning, Tanya Chapella, Development Services. The applicant is requesting variances to accommodate an accessory structure on a lot zone RSC 9. So the first variance is for the rear setback, where a minimum rear yard setback of 3 feet is required for an accessory structure less than 15 feet in height. The applicant requests a 0.5 foot reduction to the required rear yard to allow a setback of 2.5 feet. The second variance is for the rear yard coverage. So per the Land Development Code, section 61104, accessory structures may occupy required rear yards, provided that such structures do not occupy more than 20% of the required rear yard. The applicant is requesting a 7.5% increase to the permitted coverage to allow a required rear yard coverage of 27.5%. I have two findings. The first one is that the parcel has been certified as a legal non-conforming lot, and we have the case is a 20-0685 in the record, and that is because of the lot it's not complying with the minimum upland area required for a septic tank. Then the second finding is about a code enforcement case that we have for this property. There are several violations, including residential use of the accessory structure by a tenant. So per the Land Development Code, Section 61104A, accessory structures shall not be utilized for living or sleeping purposes, including guest visits at any time. So the applicant has advised staff that the accessory structure will be utilized as a utility shed. And that concludes my presentation.
All right, thank you so much. Good morning.
Good morning. My name's Ronnie McCullough.
I'm Deborah McCullough.
Thank you.
Address 6403 North 45th Street, Tampa. As she said that we have a violation. This is Greek, this court system. So
It's Greek to a lot of people, don't worry, it's fine.
And yeah, as she said, my setbacks weren't met on the property. So it's allowable of 20%. Mine exceeded 20% by 7.5%. So I'm asking for that 7.5% variance for the setbacks of the property. Also, in terms of using the codes, it's no longer used for living quarters. It wasn't, we just, it was helping this lady who was living on the street, helping her to better situation. But we understand that we couldn't do that because it's not designed for that. So it doesn't have a kitchen in it. It has a restroom, but it doesn't have a kitchen in it. And it's not used for living quarters at all.
When did you buy the property? What year?
2005, I think it is.
And was the accessory structure there when you bought it?
No, it wasn't.
You put it on the property?
I put it on the property.
Okay, all right. That was my only questions, unless you had anything else. That's it. Okay, thank you so much. Did you want to say anything? All right, thank you. If you could sign in with the clerk's office. I appreciate it. Thank you for coming down. All right, is there anyone that would like to speak in favor? Anyone in support of this application? Seeing no one, anyone in opposition? No one. Mr. Hisney, anything else?
No, ma'am.
All right, then with that, we'll close variance 20-0522 and go to the next case.
Okay, our next case is item G6, variance application 20-0680. The applicant is Joseph B. Bricklemeyer Law. The applicant is requesting a variance to lot development standards and also a variance to encroach into the required wetland setback. Staff findings will be presented by myself. The applicant requests a zoning setback variance to accommodate a proposed attached garage for an existing single-family home on property zoned RSC6. Additionally, the applicant requests a wetland setback variance for existing improvements in the rear yard. But with regards to the attached garage, a minimum front yard setback of 25 feet is required in the RSC6 district. The applicant requests a 5-foot reduction to the required setback to allow a front setback of 20 feet. With regards to the wetland setback, no filling, excavating, or placement of permanent structures or other impervious surfaces is allowed within a required 30-foot wetland conservation area setback. The applicant requests after the fact approval for a seawall, pool, and decking existing within the 30-foot wetland conservation area setback. Applicant requests a 30-foot reduction of the setback to allow for a setback of 0 feet. A couple other things you'll see on the site plan that was submitted by the applicant that there is that it shows a plastic shed between the house and the west property line of the property. According to the applicant, that shed has been removed. Staff has calculated the building coverage on the lot with the proposed garage and finds that it'll be approximately 28%. Maximum building coverage of 40% is allowed in the RSC6 district. And then with regards to the wetland setback being in effect, the code says that no setbacks are required landward of a seawall, which is constructed pursuant to the approval of appropriate regulatory agencies. A search by staff produced no permit from these agencies. Therefore, the wetland setback requirement is deemed necessary. Let me point out that if you have any questions about the conservation setback, Carla Shelton of our staff is on hand virtually to answer any questions about that.
I do have one question about that. If we could
Carla,
speak with Ms. Shelton.
Good afternoon, or good morning rather. This is Carla Shelton with Development Services.
I just have a question about that wetland setback and the lack of permits that were found. So conceivably, this then would apply to anyone on that canal that has a pool or some other improvement in that 30-foot setback. Is that correct?
That's correct. We didn't find a permit that specified this address for the seawall. I'm assuming that the seawall for the entire canal was built at the same time. So it's very likely that we won't find a permit under any of the other addresses along that canal as well.
The staff report in the backup indicated that it's estimated that that canal and seawall was built in the 1950s, early 1960s. Is that your information?
I'm not sure exactly when it was built, but it was definitely built prior to our current code being adopted that included the wetland setbacks.
Thank you. That answers my question. I appreciate it. We'll go to the applicant. Good morning.
Good morning. Joseph Brickelmeyer. I'm at 601 West Ashley Suite 700, Tampa, Florida, 33602. I'd like to handle them in order of easy to complicated, I think. The wetlands, I think it's pretty evident that everybody in the neighborhood is in the same situation were they to go apply for a permit. They would find out that they built their pool or their pavers or whatever they've got in the backyard there within that 30-foot setback, because most of those yards are not any deeper than my clients. So any questions on the wetlands?
No.
Okay. The second is the setback. So wanted to see if you had 8709 Thornwood Lane in the backup. I submitted that package. That's a prior variance for 11 feet from 2006.
I do not have it in my printed backup, but I do review all of the documents that were filed in the county's optic system. So if you filed it ahead of time, I will have it.
Okay, I'll get copies back because I got to submit the letters.
If you just read me that variance number again.
It didn't come out as a variance number. It literally doesn't have a number on it. 2006, stand by, pull it up. It was, there we go. Variance 06-1967.
Okay.
TNC.
Okay, perfect. Thank you.
For 8709 Thornwood Lane.
All right, go ahead.
Okay, and that was an 11-foot setback. My client is asking, put the site plan here.
Mr. Brickelmeyer, I don't think we can show, I have that survey in my backup. We can't show documents off of an iPad or a cell phone because you can't submit them into the record, but that particular document is a part of my backup survey.
I'll speak to that.
You can just talk off of it.
Mr. Brickelmeyer, I can give you a paper copy if you want.
I'm fine. I can speak to it as long as the hearing officer's got something to look
I have
at.
it. Yes, sir.
So the situation we've got here is the location of the house is such that with the variance of 5 feet, the 5-foot variance starts at the west corner and decreases to 3 feet on the east corner because of the orientation of the lot and the orientation of the house. So it actually gets smaller as you move to the east, but it is still a 5-foot variance. With that variance, the garage is 21 feet 4 inches deep. Without that variance, the garage is 16 feet 4 inches deep. A Toyota Camry is 16 feet long. My client's two vehicles, both of which he uses for work, are a Ford truck and a Dodge Durango. The Dodge Durango being the smaller, 17 foot 9 inches. And this is pertinent, and I'll get to it. If the variance is not granted, my client is still going to build the garage. It's going to be 3 feet short on the west end of where it would end up, and it'll be 5 feet short on the east, or on the east end, 5 feet short on the west end. But it will not be usable for a car because it'll be so small. He doesn't have a sedan, and even if he did, he would have about 4 inches on either end to fit it in there. So the garage is basically unusable without the variance for all practical purposes. So if the variance is not granted, he will build the garage within the setback, and then he will still have vehicles in the driveway. So just wanted to point that out, that there may be some issues that are adjacent to that. I've got two adjacent neighbors to the west. Chandler Rapson is directly adjacent to the west, and Mr. Oriole is one lot down to the west. They have non-objection letters that I will provide to the clerk's office. If the variance is not granted, the garage, again, as I stated earlier, would effectively be unusable. The cars will still be parked in the driveway and the garage will still get built. The view will effectively become more blocked. And the precedent of allowing an 11-foot setback in the adjacent neighborhood, another canal neighborhood, one street over to the north, was for 11 feet. That's the 8709 Thornwood Lane. With that, I don't have anything additional unless you have questions.
I don't at this time, but thank you. If you could please sign in. All right. Is there anyone at this time that wants to speak in support? Anyone in favor? Yes, if you could come forward. While you're coming forward, is there anyone else that wants to speak in support that's in the room? Okay, good morning. If you could give me your name and address.
My name is Brittany Machado, 8710 TD Lane, and I am for the variance.
All right. Thank you for coming down. If you could please sign in. All right. And I know I have one person to speak virtually in opposition. Is there anyone in the room that would like to speak in opposition? Yes, if you could come forward. Are you the only person that wants to speak? If you could go ahead and come forward just so we can allocate the time. We have 15 minutes total for everyone. So I see 3 people in the room and I believe we have 1 person virtually. Okay. So Allison, if we could just divide that up. Good morning. If you could give us your name and address.
Yes, I am Catherine O'Donnelly. My address is 3225 South McDill, Suite 129284, Tampa, Florida. And I am here on behalf of the next door neighbor, Miss Gertrude Foster. She is a 29+ year resident of the Baycrest neighborhood. And I'm here to speak on behalf of her. And she has many other neighbors who are similarly concerned about the front setback variance. So that is the subject of what I will speak to, is simply that front yard setback.
May I ask, is she the neighbor to the east?
Are you to the east? Yes, that's right.
Thank you.
Yes, ma'am. Thank you.
Thank you.
And I do have some documents that I will distribute. One set for the clerk and one for you.
Thank you.
The Baycrest neighborhood is a neighborhood that was developed in the 1960s. Its pattern of development has largely been maintained and preserved over the years. And the request to encroach into the front required setback is not compatible with that pattern of development, and it would cause significant harm to the neighbors. Ms. Foster was also canvassed by the applicant before he purchased the home. She explained that in no uncertain terms would she ever support something like this. And so the applicant proceeded, purchased the home, and we are here today. I think if you were to drive through the neighborhood, the inappropriateness of encroaching into that front yard setback would be quite apparent. So I want to just bear that in mind. I think it would be very obvious that this is distinct and incompatible if you were to simply drive through. But what I do want to do is just walk through all of the legal requirements one by one and provide some information on that front. So first, the alleged hardships or difficulties are unique and singular to the person or property requesting the variance. There is nothing unique or singular about this person or property. I'd like to highlight in the package of documents, the first tab, Exhibit A. I have provided aerial photos that show the first is zoomed in view of Tahiti Lane. You can see the applicant's property is marked with a small white symbol. The following page behind that is a little bit further zoomed out view. And then behind those aerial photos, you will find aerial photos of all of the other streets in the Baycrest neighborhood. And in providing these, I'm attempting to give you what would be the feeling of driving through and seeing that all of those front setbacks, they really are a key characteristic within the Baycrest neighborhood. It's very consistent and very notable that that has not changed over the many years that this neighborhood has existed.
You have about a minute left as we divide up the 15 minutes. I don't know.
I'm gonna take a good chunk of it, and then
Okay.
we'll probably have 2 that might take about.
So you've worked this out with the
Yes, ma'am.
folks in the room. Perfect.
Yes,
Thank you.
Thank you.
Okay. Yeah, we'll just keep it at that
Thank you.
and monitor it. Thank you. Go ahead.
And then I would like to turn to Exhibit D, which is sort of a survey of the existing gross area of all homes on Tahiti Lane per the property appraiser data. You will see that the applicant's site has the largest gross area of any property on Tahiti Lane. In fact, in its existing form, it is 16% larger than the second largest home on the street. And so the neighbors have a strong feeling this home is already built out. In fact, it's larger than seemingly all of the other homes around it. Next, I'd like to look at Exhibit C with you. The applicant has made note of a 2006 variance, and I think it would be wise to take a closer look at that since it's the singular analogous situation presented. I pulled a document from that file, and you will see that this applicant in 2006 says his home is 38 feet from the street, and I will build a garage 27 feet from the street. The subject application before you today is to encroach and build at the 20-foot mark. And so I don't think this is an analogous application. In fact, I think you may find that variance was for a side setback. There was one letter in the file. A neighbor whose house was presumably adjacent supported the request. So I think that's quite distinct from what we have here today. And then in terms of neighborhood opposition, I've also included at tab D, a list of all of the addresses that are included in this package of letters. There are, I believe, 54 or 53 addresses. Some households have submitted more than one letter on behalf of their home. So I'd like to move on to the next standard, which is that the literal interpretation of the code would deprive the applicant of rights commonly enjoyed by other properties. Other properties are not enjoying these rights. In fact, as I just spoke to, the singular example provided is not a variance to the front yard setback. And the applicant is not going to be denied anything that others are enjoying elsewhere in Baycrest. Next standard, the variance if allowed will not substantially interfere or injure the rights of others. I've noted Exhibit D in the package. Also, for those who are here in opposition, if you could just raise your hand. I know a couple of y'all might speak. And there are others online who are also monitoring and observing this hearing. The neighborhood feels they're at risk of losing a key component of what makes Baycrest such a beautifully designed and maintained neighborhood. So they feel very strongly they will be injured. The variance, this is the next standard, the variance is in harmony with and serves the general intent and purpose of the code and comp plan. And we do not feel that that is the case. The future land use Res 4 is suitable for, quote, low density residential development. And as I stated earlier, referring to Exhibit B, this house is already quite built out. Another standard that I think is really key here, the situation does not result from self-imposed harm. As the applicant explained, this is really 100% resulting from a self-imposed situation. The applicant was aware before purchasing the home that there were issues, that this was not going to be supported. And the applicant is speaking to things like a preference for the type of vehicle that one wants to drive. And that's just not an appropriate legal standard for a variance. Finally, allowing the variance will result in substantial justice being done. We feel very strongly that that is the opposite of what would occur here. And in fact, this would set a very dangerous precedent and encourage others to come forward and start really changing the character of Baycrest, so that it's more of a mishmash or hodgepodge of kind of McMansion style homes. So with that, I will wrap up and I will allow a couple of moments for these folks to come and address you directly.
Yeah, if they're with you, then if they could just put their name and address on the record and
Yes.
keep their comments brief.
Thank you so much.
Thank you. Good morning.
Good morning. My name's Gertrude Foster. My husband and I are not alone in objecting this unnecessary expansion. We have over 60 signatures of other residents in our community who oppose it. 2 applications have already been turned down on Tahiti Lane only, just Tahiti Lane, 8717. It's simply incompatible, non-conforming with our neighborhood. Like she said earlier, and I will state, the home has already been built up. Allowing a build out into the setback will set a terrible precedent and will devalue Baycrest's aesthetic appeal, not to mention devalue our homes. So we and 63 or over 60 of our neighborhoods plead that you deny this variance. Please preserve the integrity of our beautiful neighborhood community and do not allow this unnecessary expansion to go ahead.
Could you give us your address for the record, please?
8708 Tahiti Lane.
Perfect. Thank you so much. If you could please sign in. Yes, next.
Hi.
Good morning.
My name is William Wise, and I reside at 8707 Tahiti Lane. My wife Elsie and I live at 8707 Tahiti Lane, directly across from the 8710 Tahiti Lane house that is the subject of the variance. We oppose the proposed variance. We have lived in our house for over 35 years. The street between our house and the house at 8710 is very narrow, and there are no sidewalks. Children play in the street, and our grandchildren visit us often. Our 10-year-old has Down syndrome. As drivers approach our house, there is a curve which makes visibility extremely difficult as cars go through the curve. The owners have 2 very large trucks. If the front of the 8710 property were to be extended, this would decrease visibility and create dangerous and unsafe conditions for children that live and play on the street and for our grandchildren. Also, in the past, we have had 3 car accidents where the previous people that lived in 8710 backed into the cars parked in the street in front of our house. If the property were to be extended, there is not enough room for the owners to maneuver. The owners have very large trucks, and there is very little room to back out of the driveway safely. If the 87 property were to be extended, it would make things more difficult and unsafe. Because of the dangerous and unsafe conditions that the variance would create, we oppose the variance. Thank you.
Thank you, sir. If you could please sign in. Is there anyone else that would like to speak in opposition that has not spoken yet? Yes, ma'am. If you just had one brief comment.
I just want to comment that it's not 8717 Tahiti Lane that was denied twice for the variance for the setback. It's 8715.
All right. Thank you for that clarification. We have one person that wanted to testify in opposition virtually.
Good morning. My name is John Housland. I live in Baycrest, 8429 Flagstone Drive. And I echo the sentiments previously stated in opposition of this. I do think that it would change the character of the neighborhood. We have a very social neighborhood, and it's not uncommon for folks to walk out in their driveway, look down the street and wave and say hello to their neighbors 2, 3, and 4 doors down. And this extending a garage out this far would preclude being able to do that.
For your testimony.
Thank you.
I'm sorry, did I cut you off? Was that
No, that's it. Thank you.
your comments? That was it.
That's all. Thank you.
Thank you so much. All right, seeing no one else that wants to testify in opposition, we'll go back to county staff. Mr. Hisney, any further comments on this request?
No, ma'am, unless Carla Shelton has something to add. Carla?
No, I have nothing more.
Thank you. Then we'll close that portion and go back to the applicant who has 5 minutes for rebuttal.
Yes, ma'am. I will provide pictures of overheads to show the difference in what we've got. I've got them on the iPad, but if I can't show them, even though I'm going to provide them back in the record, I'll have to provide them after the fact.
Once the hearing is closed, you cannot submit any additional documentation. It has to be submitted into the record.
Okay, can I show these and then provide the printed copies?
You can't show them off. Mr. Clark, please verify. It's my understanding you can't show them electronically as he's not able to confirm that they can be submitted. Is that correct?
Can you hear me? Sorry, I got some feedback.
Yeah,
how about now?
Go ahead.
if he has physical possession of what he wants to show, that's fine. You can't show something off of a phone or a tablet or something like that if you're not also submitting it a hard copy. But if he actually has physical possession of what he intends to show, then that's okay.
Sure, I understand the circumstance. So
So I don't have the printed copies with me, if that's the clarification.
Mr. Clark, he does not have those with him to submit.
Okay, so if he can't,
he's proposing to show copies off of a tablet.
So if he
submitting them into the record today before the conclusion of the hearing.
Understood. If he cannot provide them here at the hearing before you close the hearing in terms of providing physical copies, he cannot just show them off of the phone or the tablet.
So we can't accept that, but you're welcome to describe whatever you'd like.
Okay, what I will say is two things. One, the opposition said something about distance from the street that really is irrelevant because the code calls for a setback, not distance from the street. That's an irrelevant fact. 25 feet, the applicant's asking for a 5-foot variance. So the 8709 Thornwood Lane, the setback encroachment was 11 feet. So that's the pertinent fact, not the distance from the street. Second thing is, one of the opposition came up and said that the concern was the visibility down the street. My client is going to build the garage. So really, it's a distance of 3 feet on that side as you come around that corner. So he's going to build the garage within the setback or outside of the setback, and he's going to end up having to park the car in the driveway because of the fact that it will not fit in the garage as it's going to be built. So the view is going to actually be worse, not better, because of the allowing the variance will make the view worse, not better. Or not allowing the variance to make the view worse, not better. That makes sense. With that, I don't have anything else except for other questions.
No further questions for me. Thank you for your testimony. So with that, we'll close variance 20-0680 and go to the next case.
All right, our next case is item G7, variance application 20-0591. The applicant is Knox Street Development Company. The request is a variance to lot development standards. Staff findings will be presented by Steve Beachy.
Good morning, Steve Beachy, Development Services. The applicant is requesting a setback variance for a warehouse office development on a property zoned SPI AP5. Per Land Development Code Section 60101, the required minimum rear yard setback in the SPI AP5 district is 20 feet. The applicant requests a 10-foot reduction to the required rear yard setback to allow a setback of 10 feet from the north lot line adjacent to the Seaboard System Railroad, which is also zoned SPI AP5. That concludes my remarks.
Thank you so much. Yeah, time for the applicant. Good morning.
Thank you, Ms. Finch. For the record, Michael Horner, 14502 North Dale Mabry Highway, representing the applicant and owner. I'm going to be brief, Ms. Finch. This is fairly straightforward. This is in the light industrial plan sector of the comp plan. My client is proposing a office warehouse facility with a number of buildings being proposed abutting the railroad track right of way. It is zoned SPI AP5, which requires a 20-foot rear setback. I could just point to the graphic. This aerial is overlaid. And I think you can make out this is where our buildings were proposed as the 20-foot setback required. This existing building is right up to a 10-foot setback. This existing pole barn structure is at 10 feet. Here's the right-of-way, the railroad, and these structures are also at 10 feet on the other side. We do not abut any other lot. This only applies to the north property line setback. We have no public interest issues or conflicts. And you can see with the 10-foot setback, Ms. Finch, where we would be taking the buildings now to 10 feet. We have a couple surface water designations that we are allowed to go up to. We can't encroach, and we're not doing that under director's authorization, so we have no environmental issues. We have no compatibility issues. Again, this is directly abutting the railroad track. This is for a use that is permitted by right, consistent with the light industrial plan, consistent with the zoning We just need to move these buildings just a little bit further. It creates more square footage, which is paramount in this redevelopment effort. It'll be quite expensive. That's all I have for you.
All right.
Be happy to
thank you
answer
so
any
much.
questions.
No, I don't have any at this time, but thank you so much. Is there anyone that would like to speak in support? Anyone in favor of this application? Seeing no one, anyone in opposition? All right, no one. Mr. Hisney, anything else?
No, ma'am.
All right, then with that, Mr. Horner, that concludes your part? Okay, good. Then we'll close variance 20-0591 and go to the last case.
Okay, that concludes our general variances. Moves us to section H of the agenda, special uses. We have one case on that portion of the agenda. It's item H1, application SUAB 20-0846. The applicant is PLFW Incorporated. The request is for a 3 PS alcoholic beverage permit, which requires a distance separation waiver. Staff findings will be presented by Laura Hurley.
All right, good morning. Go ahead.
Good morning, Madam Hearing Examiner. For the record, Keith Long, an attorney with Long Law, 2417 Lake Kismet Terrace, Cape Coral, Florida, 33993. Sorry. As I said, my name is Keith Long. I'm an attorney with Long Law. I'm here to present a special use request, SUAB 200846, on behalf of the applicant, PLFW Inc., who's requesting a distance separation waiver for the placement of a 3 PS package sale liquor license to be placed at 9630 South 301 Highway in Riverview. Just as a brief overview, the company and the applicant, PLFW, owns and operates 2 other package stores, which in general terms is a liquor store in the area that are known as Party Liquors. This will be the 3rd store, the other 2 located in Notasasa and Lando Lakes. The new location that's being proposed here before you is situated on the northeast corner of Boylette Road and US Highway 301 in a highly commercial plaza anchored by a Save-A-Lot and Bell's Outlet. As these things go, I'm just going to briefly discuss the special use criteria that are to be determined by the hearing examiner in granting this request. There is a single distance requirement that necessitates the request, that being that the proposed variations from regulations LDC 6.11.11 require that no more than 3 consumption on premise or 3 PS license uses be approved within a 1,000-foot distance buffer. As the wet zone on the record shows, there are 10 that have been historically approved and active within that 1,000-foot distance buffer. Of those 10 that are approved, 3 of them are located, 2 prior, this would be the 3rd, located in that commercial plaza that was discussed. The 2 currently existing would be at Beef O'Brady's, which is a 4COP SRX restaurant license with accessory alcohol sales and a salon in the unit at the far end, which I believe is just a 2COP license that offers, technically offers the ability for beer and wine for guests, but what I presume would be wine or champagne for the salon. The requirements allow for the approval of separation waivers if there exists special or unique circumstances where alcoholic beverage use applied for does not have significant impacts on the surrounding land uses and certain circumstances negate the necessity for the specified distance requirements. Just briefly, a couple of those. A unique circumstance would be that in this case, it's a highly commercial area. To the south, where Boylette Road is, it's buffered more or less by foliage. And then on 301, it's a pretty significant setback with regards to the large parking lot. So it's not as if it's directly bordering in either of the 2, highly commercial streets or highly traveled streets. The previous use that was approved for this plaza or this unit was a 2 APS package license, which allows for the sale of beer and wine package sale with no consumption. In this case, what we're requesting is the package sale of beer, wine, and spirits, which bumps the license up to a 3 PS package license. So just an incidental increase, in my opinion, as far as the current use that's approved and the proposed use. With that being said, the applicant contends that the variance from the literal interpretation of the codes as it relates to the 1,000-foot distance between the other existing licenses is in harmony and serves the general intent and purpose of the code and the comprehensive plan. Certainly appreciate your consideration. Thank you.
Thank you for your testimony. I appreciate it. Development Services, please.
Good morning. This is Laura Marley, Development Services. The request is for a distance separation waiver of a 3 PS alcohol beverage permit for the sale of beer, wine, and liquor to be sold in sealed containers only for consumption off the premises package sales. The proposed wet zoning will be 11,615 square feet, and it will serve a proposed liquor store. If approved, the proposed wet zoning will replace an existing 2 APS wet zoning. The applicant meets the distance separation from certain community uses and residential zone property. The request does not comply with a separation requirement of more than 3 approved alcohol beverages within 1,000 feet. There are 10 approved wet zonings in the specific types. It should be noted that number 8 from the wet zone survey is an approximated location of a 2-cop found in the notes of the wet zone survey. Staff findings and summary is that alcohol sales will be limited to package sales only with no on-premise consumption, and that only 2 of the 10 wet zonings are located in the same shopping center. The others are located across Boyette Road and Highway 301. Staff finds the request to be approvable. Approval is based upon the wet zone survey indicating a total of 11,615 square feet of floor space for the proposed use that was received September 17th, 2020, with the following condition. Approval of the SUAB 20-0846 shall rescind the existing 2 APS wet zoning of the subject premises. AB 1363 approved in 1987 for 10,544 square feet. Thank you.
Thank you for your testimony. I appreciate it. Is there anyone that would like to speak in support? Seeing no one, anyone in opposition to this application? Seeing no one. Mr. Hisney, anything else?
No, ma'am.
All right, sir, does that conclude your presentation?
It does, if there are no questions.
Wonderful.
Yes, ma'am.
Thank you for your time. With that, we'll close special use AB 20, excuse me, -0846 and adjourn the meeting. Thank you so much.